Hello everyone, I'm Anuj Nakade and you're watching LiveLaw. Yesterday on the 10th of April 2023, exactly 5 days after the Supreme Court suggested changing of the sealed cover procedure in a landmark judgment, a test for transparency has shown itself in another sensitive case. The sealed cover procedure is a way for a party to provide certain documents and information only to the court and not to the other party. The Supreme Court in the landmark Media One judgment has suggested a procedure to replace the sealed cover procedure with a more transparent process. We at LiveLaw did a video about Media One case, the sealed cover procedure, and an explainer on the alternative public interest immunity claim procedure, and you can watch them both right here. This time, the public disclosure of information has come up again in another case, which is regarding the alleged 22 fake encounters said to be conducted by Gujrat police between 2002 and 2007. The story began with a petition filed by 3 prominent citizens: the now deceased journalist B.G. Verghese, poet and songwriter Javed Akhtar, and the human rights activist Shabnam Hashmi. The long and short of the petition is that they made a very serious allegation in relation to the deaths of certain prisoners who had died in the custody of Gujrat government. The allegation further went to state that the prisoners had not died in encounters but were managed by the state to look that way. In other words, the petition said that the encounter deaths had occurred under the Gujrat government between 2002 and 2007 were fake. In response to this petition, the Supreme Court appointed a former Supreme Court judge named Justice H.S. Bedi as the chairman of a monitoring committee to monitor an investigation in March of 2012. This investigation was being carried out by the Special Task Force formed by the Gujrat government under direct orders of the Supreme Court. In 2018, the monitoring committee submitted a report to the Supreme Court in a sealed cover. In 2019, the Supreme Court decided to make the report public and revealed that the report had recommended the prosecution of 9 officers in relation to 3 of the deaths investigated by the Special Task Force. Then, in January of this year, in 2023, a 2-judge bench of the Supreme Court comprised of Justice S.K. Kaul and Justice Ahsanuddin Amaullah ordered that the files containing the evidence relating to these 3 deaths must be circulated to all parties in the petition. The parties in question being the prominent citizens, that are the petitioners, the Gujrat government or the prosecution, and the accused police officers along with the Supreme Court. Yesterday, the Supreme Court had only listed the matter to ensure that the order of the Supreme Court passed in January of 2023 was followed. Mr. Tushar Mehta, the Solicitor General of India, appearing on behalf of the government, stated that the order was followed by the government, but also told the court that they are not comfortable with the evidence being shared with the petitioners. Mr. Mehta also told the court that they have received a letter from the accused officers not to share records of the investigation with the petitioners. Mr. Mehta further said, and I quote, "These 2 petitioners are people staying in other states. They have identified particular period, have identified some encounters. They are not concerned with encounters in other states. There is a serious doubt regarding the locus and the motive behind this petition." Senior advocate Mr. Mukul Rohtagi, the counsel appearing on behalf of the accused officers, also opposed the sharing of these files with the petitioners. He said to the court, "I have a very serious objection. Once a report is now between the court and me, there cannot be a situation where all the documents are shared with somebody else who is not the PP or the public prosecutor." The point being communicated by the state and the accused is clear. Why should strangers have access to documents relating to investigations? There should be very fair considerations, especially in investigations that are this sensitive. Advocate Mr. Prashant Bhushan and Senior Advocate Ms. Nitya Ramakrishnan, who appeared for the petitioners in this case, told the court that they wish that the Supreme Court follows its own guideline in cases of investigations relating to the killings done by police encounters. The matter is at a very crucial stage where a question arises. If an investigation has been unearthed because of a petition, should the petitioners have access to records of evidence to assure accountability and transparency with such an investigation? The Supreme Court will hear arguments regarding the disclosure of evidence to the petitioners in this case on 18th July 2023. and we intend to keep you informed about the case. To make sure you get information as quickly as possible, please subscribe to our channel and press the bell icon for notifications. To read more detail and the full report by Justice H.S. Bedi, please visit our website. We will also ensure to leave a link down in the description below to the full report and the story. If you found the video informative, please like the video and tell us in the comments how we can shape our legal content to bring you your legal news in more engaging ways. Thank you.